Hello everyone and welcome to the next session. It's Margot Metcalf from the IAC group. I'm just here to fill in the first 30 seconds or so whilst everyone's logging in, ready to introduce our next speaker. Ian Wallis from the Victorian Chamber of Commerce and Industry, VCCI, is going to talk a little bit about the lessons we can learn from the British Corporate Manslaughter experience. We will have a 3-minute gap after this one, and so towards the end of the session, if we've got any questions, pop them into the live Q&A panel on the right hand side of your screen, and if we have time, Ian will respond to them. It's over to you, Ian, and thank you very much for taking some time out of your day to talk to our audience.
All right, thank you, Margot. Hello, everyone. Good afternoon. Yes, Ian Wallis from the Victorian Chamber of Commerce and Industry. And just talking about the largely the English experience in this case. So just going to talk about the lead up to our new workplace manslaughter laws, a very quick overview of what they look like, and then getting into the single legal precedent in Australia, but then looking at the English and Welsh experience with their 12 years of these types of law and their statutes and features and a few case examples as well. And then hopefully we'll have time for a question or two. But we will respond otherwise to those questions that we don't get to. So a little bit of lead up. So Daniel Andrews in Victoria promised these laws, and it fits in with a bit of a national trend, state by state, depending on Labor and Liberal governments, are I guess moving to these types of workplace manslaughter laws, and we now have 5 jurisdictions who have these in place. As part of that implementation, the Victorian Chamber of Commerce and Industry, along with 4 other industry representative groups and union representation and community and family representation, were involved in a task force, a consultation task force with the Victorian government. Hence, we know a little bit about these laws and how they came about. So a little bit of an overview. So these new workplace manslaughter laws in Victoria commenced 1 July this year. So they apply to all applicable duties under the OHS Act in Victoria. They do exclude employees under sections 25 and 32. All other applicable duties of care under the OHS Act may apply. There are no new duties, but obviously much heavier penalties for a breach of the existing applicable duties. They have focused on corporations and corporate officers and senior managers, and they focus on negligent conduct that significantly contributes to a workplace fatality. Now, with these very serious penalties or breaches, there must be very clear causal links between the conduct and the incident that results in a fatality. These new penalties are what's concerning most people. So for a corporation in Victoria, up to $16.5 million, but also individuals up to 25 years jail are the possible ceilings for the penalties. Now, the legal test is quite strong, and so it must involve negligent conduct, either acts or omissions, resulting in a great falling short of the reasonable care test for persons and organisations. A great falling short of that reasonable care test. Now, conduct can occur either in or outside of Victoria. But obviously it's a Victorian legal jurisdiction, so the incident or exposure occurs in Victoria, but the conduct can originate from elsewhere. There's also a removal of a 2-year statute of limitations And now in this penalty, there is no time limit for an investigation and prosecution to occur. And we'll explain why shortly. WorkSafe now has a specialist team of ex-detectives as an investigative team in this specialised area. So what can we learn from our, I guess, legal precedents that have brought us to this point? These laws, through the implementation period, were developed and, I guess, adjusted based on the Queensland application, but also the British experience, and heavily based on both. We have one Australian legal precedent. So this is in Queensland. This was brought before the courts for penalty in June June this year. So it's quite fresh. So this is an automotives recycler in Queensland who had an unlicensed forklift driver reversing a forklift into a man who was loading a truck in the yard. And so the company, the person died, and the company and its two directors have just recently been sentenced. So the company was sentenced to $3 million and the two directors received 10 months suspended prison sentences each. Essentially, the suspension was due to their refugee status, and if they were jailed, they would have to be deported. The court took that into consideration. So this is the single and only legal precedent that we have in Australia, or at least a modern one, as a workplace manslaughter. The British have had their version of this in place for some time. And so since 2007, they have had their Corporate Manslaughter and Corporate Homicide Act 2007, and this supports their Health and Safety at Work Act 1974. To date, only 26 prosecutions have occurred in the 12-year period that these laws have been in place, and most of those were due to guilty pleas, and so they were uncontested by the courts. All bar one of these resulted in small to medium businesses being prosecuted. Only one large complex business has been through the courts. They've resulted in a range of penalties, the highest being £1.2 million, an average of £300,000, but even down to £8,000 for a corporate manslaughter conviction. As a result of that range of quite low penalties, the UK government introduced some new sentencing rules for the courts in 2016 to strengthen the sentencing outcomes. And I'll mention those when I summarise. So the average time from incident to legal outcome is also around 3 years due to the complex investigations that are needed. Point to note is the fatality rate has not improved. However, serious injury rates have declined in the UK by about nearly 40%. These corporate manslaughter statutes, they commenced in 2008, they abolished killing by gross negligence, manslaughter, and created the Corporate Manslaughter Act. This form of legal change caused the abandonment of what's called the identification doctrine, so that a corporation can now be attributed with liability for the crime. Historically, the need to identify a single controlling mind posed a barrier to holding a corporation and complex corporate structures to account. So this type of law has been able to overrule that long-standing identification doctrine. The British Act created the offence of to enable the courts to impose direct personal liability on a corporation, where that was incredibly difficult previously. It enables the conduct of all management to be considered, not just one person, when ascertaining where systemic failures. And the offence applies not only to individuals, in the British case, it does not apply to individuals. It is purely a corporate penalty. And there are some exemptions for public bodies going about emergency work. So the organisation in the UK must owe a duty of care that has to exist already. And the way activities are managed need to amount to a gross breach of that duty. It must result from the activities that are managed by and organised by senior management, and the death must be caused by these activities. Which brings us to a few cases. So examples are JMW Farm Limited, where this is disturbingly similar to a Victorian case that occurred 12 months ago, where a person inside a large steel bin cleaning the inside of the bin elevated on a forklift and the bin toppled off, crushing the employee, the director driving the forklift, I believe unlicensed. And then Martinisation London Limited, they had two persons lifting a sofa from the ground to an elevated balcony, and everything went wrong, and two people were killed in that incident, pulled off the balcony, we believe. And the quite a poor history leading up to this incident as well. The only large corporation to be convicted was CAV Aerospace. Essentially an employee was crushed by stacks of metal billets stored at the Cambridge site. And the company was having difficulty controlling the amount of incoming goods, so overstocked storage facilities. A sole director repeatedly ignored concerned emails from site managers, and an OHS consultant had also warned of the risks in strong terms, was the quote. So solutions were rejected solely on cost grounds, therefore no risk assessment was applied and no reasonably practicable test conducted. And so these collective management failings led to the death in the warehouse and a $600,000 penalty. So these laws have been in place in the UK for 12 years, only 26 cases over that period, which results in about 5% of total fatality cases, workplace fatality cases heard before the courts. They're all small business, majority are all small business. And penalty ranges from 1.2 million to £8,000. The UK government introduced new sentencing laws to strengthen the outcomes. Now the minimum is a £300,000 fine, and there is no maximum penalty, no ceiling available. The average time is around 3 years, and a point to note about the Grenfell Tower fire: this is still being investigated and awaiting trial, and is likely to be heard under corporate manslaughter. And again, the fatality rates remain flat, but serious injury rates.
Sorry, Ian, just under 1 minute to remain.
Thank you, Margie. I don't believe there's any enforceable undertakings, was one question, so not so far. And
we will send those questions through to you, Ian, if you're able to respond to them after the event. That would be fabulous.
Thank you, that'll be easier.
Yeah.
Thank you, folks. Appreciate the ability, and have a good day.
Thank you, Ian. We appreciate you coming online and helping us.